Okay. All right. Well, everyone, thank you for joining. My name is Lauren Joe. I'm an immigration attorney in New York City. This is my third presentation with the new school, for international students. I did a similar presentation to this in January, and then I did another H-1B specific presentation I think in February or March of this year. So this one will be very similar to the one that I did in January that kind of covers the whole gamut of immigration options, employment, mostly focused on immigration options for students post-graduation. And it includes a little bit of F1 OPT and CPT as well for during school, but mostly focusing on post OPT options, so temporary visas and green cards. So I'll just get started here. Okay, so just a little bit about me. Like I said, my name is Lauren Joe. I'm an immigration attorney in New York. I've been in the immigration field for over a decade now. I started as a paralegal back in the day before I went to law school, and then I kind of focused specifically on immigration, knowing I wanted to be an immigration attorney. So I had a lot of internships with immigration law firms. And then after graduation, I worked for Fragman, Delray, Bernson, and Lowy, which is a large firm, a global firm, but based in Manhattan, that focuses specifically on immigration only. And then I started my own firm last year, and I focus exclusively on immigration and nationality law. I work mostly with companies and individuals on business immigration, but I also do family immigration as well. So marriage-based green cards and other types of green cards with family-based petitions, and then also US naturalization. And I live in Connecticut with my husband, Andrew, and cat Yogi. I just recently moved from Brooklyn in August. So I hope everybody stayed dry last night and today in the New York area. We thankfully didn't have a lot of flooding where I am, but lots of branches down in the yard and everything. Okay, so this is just a kind of brief overview of what we'll be going over today. Just kind of, I call it the alphabet soup of immigration. This is kind of all the different visa types, which are designated by a letter, like H-1B, F1, all that type of thing. And then I'll go over kind of the primary non-immigrant visa options that most individuals post-graduation would be getting. And then I'll briefly go over the immigrant visa options. So in immigration law, immigrant is kind of a term of art, and that means permanent, if you're coming to the US permanently, meaning a green card, and then anything else would be temporary, a non-immigrant visa. So like an H-1B or F1 is a non-immigrant visa. And then at the end, I'll just kind of briefly go over the COVID updates. There's still, unfortunately, a lot of restrictions and delays going on that are COVID-based. And if anybody has questions, just kind of put them in the chat, and we'll get to them at the end. I'm hoping to kind of keep the presentation to under an hour, and so we'll have at least half an hour for questions, and then we'll just kind of do those at the end. So these are the different types of immigration categories. Like I said, there's non-immigrant, temporary, immigrant, permanent, but you're still not a citizen yet. That would be green card, permanent residency, and then citizenship. So for non-immigrant, kind of the primary categories that are work authorized are E1, E2, treaty, trader, and investor, which I won't go over today because that's not as common for students graduating. But if you do want to talk about that, just let me know and we can expand on it in the Q&A at the end. E3, Australian specialty occupation. This is a visa specifically available for only Australian citizens. It's pretty much identical to the H-1B, but only for Australians, and you don't have to enter the H-1B lottery. F1 student and OPT and STEM OPT, I'm sure almost all of you are probably on the F1 visa or J1 visa, and probably know a decent amount about OPT and STEM OPT, or you might be on it, or have questions about it, kind of going into that phase once you graduate. The H-1B specialty occupation visa, that is kind of, for a lot of people, the holy grail of non-immigrant work visas, but it's hard to get, just kind of out of pure luck. So we'll talk about that in the lottery. The H-1B1 specialty occupation. So this is, again, very similar to the H-1B, but only for Singaporean and Chilean nationals. So that is based on a treaty, just like the Australian E3. And then the J1 exchange visitor, which for in your student context, probably primarily for PhD research scholars. The L1 intracompany transferee, I won't talk about this because this probably won't come up in your situation if you're in the US going to school. The O1 extraordinary ability. I've gotten a lot of questions about this from new school students and graduates because it encompasses artists. There's not a lot of visas that are available to artists, but I'll go into depth in that a little bit. R1 religious worker, I won't cover that. TN NAFTA professional, this is for Canadians and Mexican citizens for professional occupations. And then DACA, which is not quite a status, but deferred action for childhood arrivals. So if you currently have DACA, you can extend it and get your work authorization. If you have not applied for DACA, unfortunately, it's on hold right now. This is another one of those government programs that's kind of been in flux over the past decade almost, where sometimes it's on, sometimes it's off, and it kind of just depends on what's going on with the courts. Right now it's off if you do not have it already, but if you have it, you can extend it. And then the immigrant visa categories for green cards, it's broken down into preference level. So EB1, 2, 3, 4, 5, and then the diversity lottery. EB1 is kind of special categories for if you have extraordinary ability, very similar to the O1 temporary visa. If you're an outstanding researcher, or if you're a multinational manager or executive. And these EB1 categories are special because you don't have to go through what they call the PERM process, which for EB2 and EB3 categories you do. And I'll go over the PERM process later, but it's basically a testing of the labor market to see if there are available US workers for those positions before they'll give a green card to someone in those jobs. And then EB4 is not very common. That's kind of, right now you're hearing about the SIV visas for like Afghan interpreters, things like that. That's EB4. And then EB5 is for investors who are investing, I believe the minimum is around $900,000 into a business. And then the diversity lottery, I always encourage people to check every year. It's around October. It's free to enter. If your country is on the diversity lottery list, meaning it's not one of the highest population immigration countries into the US. So for instance, India would not be on the list because it's a high immigration country. But every year, I forget how many countries are not on the list, but like maybe like the top certain like 10% of countries are not on the list, and then everything else is. So you can just enter this lottery. It's very low odds, but it's free to enter. And if you get selected, you can just get a green card. It's great. So I always encourage people to do that, just kind of as a backup, even if they do have other work visa options. And then citizenship, if you want to, after 3 to 5 years of having a green card, depending on how you got the green card, you can apply for US naturalization. So it's 3 years if you get it through marriage to a US citizen, and then 5 years if you get it through like work or something. Okay. Okay, F1, student visa, and optional practical training, OPT. So this is something that probably a lot of you are familiar with or have looked into if you're not already on your OPT or STEM OPT. So OPT is a temporary employment that is directly related to your area of study at the university. So you have to be in F1 status at a US university. And if you're eligible for OPT, you can get up to 12 months of OPT employment authorization after graduation. So that would be the post-completion OPT. There is pre-completion OPT as well, but it sort of subtracts from that 12 months. So I usually recommend using CPT, which I'll cover on the next slide, if you're using, or if you're doing like a summer internship or something that's related to your degree program. And then, so pretty much everyone is eligible for the 12 months of OPT. And then some people, depending on their degree field, if it's a STEM, science, technology, engineering, or math field, you'll be qualified for another 24 months of OPT work authorization. So you'll get a full 3 years of work authorization after graduation. And it must be with an e-verified employer. So sometimes I get questions from students who have a job offer for their STEM OPT, but it's a small company and they don't have e-verified. I've been able to convince companies in the past to get e-verified because it's free and it's pretty easy sign-up process. So it's not like something that's impossible if they're not e-verified right now. And you and the employer must complete the detailed training plan. So this is a government form, Form I-983, jointly with the employer. And since it is technically a training program, optional practical training, it'll go over like what your job is, what the company is training you on, skills you'll learn, how you'll be supervised, who is supervising you, like when they'll check in on you and do updates. And the employer really has to be aware of these updates in case there are site visits from the government. So this program is run by ICE, and ICE can, I don't know if they're doing it much anymore, but under the Trump administration, there were STEM OPT ICE site visits where companies would get, I believe it was 48 hours notice, and then some ICE officers would show up and just look at the training plan, look at the office, ask questions to the manager and the foreign national student. So you want to make sure everything is kind of above water. I would say one of the best benefits of the STEM OPT program, other than just getting extra time of work authorization, is it allows multiple entries into the H-1B lottery over 3 years. So we'll get into the H-1B lottery, but the odds of being selected, especially in your first round of the H-1B, are not super high. The odds of being selected are about 30%. So if on your first year after graduation, you have your employer files for an H-1B lottery registration for you and you don't get selected, if you have STEM OPT, you still have 2 more years of work authorization and 2 more chances of being entered into the lottery. If you have only that 1 year of post-completion OPT, then that really reduces your odds of post-OPT work authorization, at least under the H-1B category. You may be eligible for other categories depending on your country of citizenship, but not everybody is. So the CPT, the curricular practical training, very similar to the OPT, except it's during your F1 program, so it has to be before that end date on your I-20 form. And this is temporary employment that's directly related to your area of study during your program that's integral to part of the school's curriculum. An important factor is whether it's full-time or part-time and how much CPT time you use. So 1 year of full-time CPT eliminates your eligibility for OPT. So you don't want this to happen if you are eligible for a year of post-completion OPT or 3 years, including that STEM OPT. So you need to keep track of the time. Even if you do 10 months of full-time CPT, that's fine, but just don't do 12 full months unless you're okay losing your OPT time. And you must have the job offer from the employer before you start before you apply for CPT with your DSO in the International Student Office. And just as an example, many students use CPT for summer internships or winter, or even just during the school year, any sort of work authorization. And for any of these, OPT, STEM, and CPT, you can reach out to Anya and the team in the International Student Office, because they're the ones who handle all of that with the new school. Okay, so the H-1B specialty occupation visa. Like I said at the beginning, this is kind of the holy grail for some people for work authorization in the US. If you're from a country that does not have its own special visa category, like the E3 or the TN or the H-1B1, that are all very country specific. If you're not from one of those countries, you're probably relegated to the H-1B specialty occupation visa. So the requirements for this category are, so it's a professional visa, so the job must require at least a bachelor's degree or equivalent in work experience in a specific field as a minimum entry level requirement. And then the applicant, the employee, must have that same degree that the job requirements require, and in that same field. So for example, you can't just have a bachelor's degree. Like if the job requires a bachelor's degree in mechanical engineering and you have a bachelor's degree in art history, that's not going to work. It has to align in a similar degree field. Also that very important, the employer must pay at least the prevailing wage for the occupation in the geographic area. So the prevailing wage is a wage level that's set by the Department of Labor, and there's a library of occupations online. It's called the FLC Data Center. I'll go to that in the next slide and show an example of what that looks like. But it depends on what the occupation is, what the experience level for the position is. So there's 4 different levels, 1 being entry level, no experience required, and then 4 being the highest level, like a director, where there's a lot of experience required. And it's broken down into geographic areas. So the same position for example, for a lawyer in New York, if you look at the prevailing wages for a lawyer in New York City, they're going to be very different than a lawyer in Oklahoma or something, where the wage level and just the cost of living is lower than it is in New York City. So it really depends on where the person will be physically working, whether they're working at home. That's a whole other kind of wrench that's been thrown into the H-1B process over the last year, with a lot more people working from home, which could benefit you depending on where your home is. So those are the requirements for just obtaining that visa. But before you can even get to the process of applying for it, you have to go through the lottery selection process. Then you have to, I'll go kind of skip to the lottery process after I go through these, and then the sample of the prevailing wage. But so you determine the prevailing wage. So like I said, you look at the online, either your employer or your employer's attorney will look at the online prevailing wage library, determine what category fits that job, what level, and then see what the prevailing wage is. And hopefully it's lower than what the employer is offering you. I've seen a lot of situations where it's very close, and sometimes the employer will bump up the wage to exactly what the prevailing wage is. And I've seen, unfortunately, situations where the prevailing wage was like $20,000 higher than what the employer was willing to pay. So they decided not to apply for the H-1B for that person because they just couldn't afford the prevailing wage for that. So once they get the prevailing wage, the employer has to post a notice with either at the work site or online through like the company's intranet if they have that. So it's a notice notifying the employees at the work location where you'll be working that they're hiring an H-1B worker. They're going to be in this occupational category. They're making this much money. And sometimes they put a wage range, so it doesn't have your exact salary. And then once that's posted, then your labor condition application with the Department of Labor, which is essentially a form that the company is filing with the Department of Labor saying that they agree to pay you the prevailing wage. This is the occupational category, this is the wage, and it's kind of an attestation about all the wage requirements for the H-1B. That takes about a week to be certified by the Department of Labor, and then the certified LCA will go into your H-1B application, which is number 4 there, the I-129 petition with USCIS. So the I-129 is a USCIS form, so it's US Citizenship and Immigration Services. And there are 2 different ways to file your application. So if you're currently in the US and in status, so if you're in F1 status, say you're F1 OPT and you're working for the company that is filing for your H-1B, which oftentimes that's how it works. So you work for them for a year or so after graduation, and then they enter you into the lottery if they want to keep you full time. You can do a change of status within the US. So F1 to H-1B, and then on October 1st of that year, you would automatically switch over to H-1B status because that's when the government's fiscal year starts. If you are not in the US or you have to travel outside the US for whatever reason, you can travel to obtain your H-1B visa stamp at a US consulate abroad. Right now, I don't recommend this because so many consulates are still only operating on an emergency basis. It's hard to get appointments, even if you can get one for a lot of countries, including India. I think like the earliest appointments are like April of next year for right now. So that's like over a six month wait. So it's better not to risk that if you can avoid it. If you are outside the US, when you file the application, you have to file it that way. And then the only way you can change to H-1B status is once you get that visa stamp at the US consulate and then enter the US in H-1B status. But in the past, that was much more easier said than done now. Now, I would not recommend that if you're in the US in F1 status. Okay, so this is a sample of the prevailing wages. I just pulled the page for commercial and industrial designer in the New York metro area. So the occupational category is 271021. It's called the SOC code. Every kind of category has their own SOC code. And then you see level 1 through 4 wages. So level 1 wage, so that would be if you were in this type of job and the job required just a bachelor's degree, no experience, maybe 1 year of experience or internships or something like that. And then the minimum is $52,894 per year. So as long as the company is paying you more than that for an entry-level position, then you're fine. And then below it has a little description. If you were on the website, so I have the website there, flcdatacenter.com. If you click on that blue, the number 271021, it brings you to a page that really goes into the details of what that occupation is, because sometimes modern jobs, the government's job library has not really kept up with all these categories. So sometimes it's hard to really fit your job into one of these categories. But you can go on the website and kind of just play around and see what the prevailing wages are. And this is, again, based on exactly where you physically will be. If the headquarters is in New York and you work in Atlanta, then it will probably be a lower wage in Atlanta. So you have to look at the wage exactly where you will physically be sitting. If you will work in multiple locations, you have to meet the prevailing wage in all locations. Okay. Okay, so the lottery. So this is the difficult part about the H-1B. Not only, like, you could totally qualify and meet all those requirements if you have the bachelor's degree. Oops, was that Anya? No, okay. If you have the bachelor's degree and everything, but the problem is there are only 85,000 H-1Bs visas available per year. So 65,000 new ones per fiscal year. And then they have 20,000 set aside for individuals who hold US master's degrees. So a foreign master's degree, you still get lumped into that 65,000. But if you're getting a master's degree in the US, you kind of get 2 bites at the apple, which is good. The government fiscal year starts October 1st each year, and they permit applications to be filed up to 6 months in advance. So April 1st is really the first date that you can apply for an H-1B with a start date of October 1st. You cannot be in H-1B status until October 1st at the earliest. In March of each year, so this just started 2 years ago, this new online registration system, your employer will put an entry into the lottery online with USCIS. The dates kind of vary, but it's usually a 2-week window of when they can enter these applications online. There's a $10 government filing fee. It's a really pretty easy form. There's nothing about your qualifications or anything. It's just biographic information about you, your passport number, your birth date, some company information, and then that all gets put into the form and gets submitted to USCIS. After the 2-week window, they will run the lotteries. So there's 2 different ones, the 65,000 and the 20,000 for master's degrees. So that's why I said you get 2 bites at the apple if you have the master's degree, because you'll get entered into the 65,000 for bachelor's. And then also, if you don't get selected in that one, you'll get put in the master's degree one. So if you get selected, you'll get your employer and or your employer's attorney will get an email notice and can check the online USCIS portal. And you'll have a selection notice that says you've been selected in the lottery. So you're eligible to now file an H-1B petition, which is fantastic because then you're one of the select few based on last year's statistics that were released by USCIS. It was about a 30% selection rate. So the vast majority of people who entered the lottery did not get selected, which really stinks. I wish it was a better system, but this is all we have right now, and I don't see it changing in the foreseeable future. So once you get that notice and you have the eligibility to file that I-129 petition, you should get started with your employer and your employer's attorney on filing that petition, because you'll only have a 90-day window from April 1st to June 30th to file that H-1B petition with USCIS. In the last 2 years, since they started doing this H-1B online lottery, they've run a second lottery in August, which in the past they never did that. It used to just be you file all your petitions on April 1st, and then they just reject the ones that don't get selected. Now, to use up all these numbers each year, so they'll select 85,000 in the lottery, but if 85,000 petitions are not filed with USCIS before June 30th, they'll take whatever remaining numbers there are left and run a lottery for those empty slots. So there might be people that enter the lottery with multiple employers and only one gets selected and another doesn't, so that slot goes empty. There might be people who leave jobs. There might be companies that decide, hey, we don't want to, or we can't afford to file an H-1B anymore. So I'm not sure how many empty slots there were in the August lottery this year, but for people not selected, it's sometimes a little glimmer of hope that they could potentially be selected, but the odds are still very low of being selected in the August lottery. And then just some more about the H-1B, the timetable for filing the petition with USCIS. It's about a 2 to 6 month processing time, but highly variable. And again, you cannot start an H-1B status until October anyway. Premium processing is sometimes available for the H-1B lottery petition, sometimes not. You just have to kind of wait on a notice from USCIS. That would be a 15-day, basically you pay a $2,500 government filing fee, and the government will process your application within 15 days. Not always available. So number 2 there, cap gap. This is important for F1 students. If you are filing as a change of status, so like I said, if you're in the US, when you file the petition and you want to change your status to H-1B on October 1st without leaving the US, but your F1 status runs out and your work authorization might expire beginning of June. Lots of times it does, because you kind of get your OPT when you graduate and you start working, so it might expire around early summertime. If you're in this situation, you can get cap gap, so it'll cover, it's like a bridge from that, say, June 1st period when your EAD expires until October 1st. And this is noted on your I-20. You'd have to get an updated I-20 from the DSO. If you file for a change of status, you're in the US, you were actually selected in the lottery and you're filing the petition. And that is one benefit that you can get. So then you're not kind of stuck out of work between the expiration of your F1 EAD and when your H-1B would start on October 1st. There's always the chance of a request for evidence on RFE from the government on your case that could delay it. That's usually the government asking for additional information about either the position, trying to make sure it qualifies as a specialty occupation, maybe your qualifications, maybe they want to see your degree, sometimes they just need something translated. They ask for all sorts of things. Sometimes their requests are a little bogus, but can be overcome, but it's just a delay in the process. An H-1B status is granted for up to 6 years maximum, but each grant of status is for 3 years. So it would be from October 1st. Say if you're going through the process this year, it would be October 1st, 2021 until September 30th, 2024. And then 6 months before September 30th, 2024, you can apply for an extension for 3 years for that 6-year period. You can only extend beyond the 6 years if you're in the green card process, and there's 2 different ways to do it. If you have a green card application pending due to country backlogs, which we'll get into in the green card section, or you have your perm application pending for more than 1 year. And then I just have the government filing fees here. And for the H-1B, your employer has to pay for all expenses included for the H-1B. So the legal fees for an attorney and all those government filing fees, there's a statute saying that you cannot pay for it as the employee. You cannot reimburse the employer. They have to pay for that. So other visa categories are not the same. So like for E3 or TN, sometimes the company can't afford to pay for all the immigration process, so the employee will pay for it themselves. But for the H-1B, the employer has to pay for it. So that's the H-1B cap subject cases. So the cap is the quota. There are some categories of employers that are cap exempt. So this means that you don't have to enter the lottery. They can just hire you and they can apply for an H-1B. These are the types of employers that are not subject. So institutions of higher education, it's a public or a nonprofit institution, like most universities, as long as it's not a for-profit university. Nonprofit entities that are related to or affiliated with institutions of higher education, nonprofit research organizations, and government research organizations. So if you are able to get hired by one of these organizations, you don't have to go through that lottery process and you can just get the H-1B. However, you cannot switch to a cap subject employer, like a private company, without going into the lottery. So it's not kind of a backdoor into other employers. If you wanted to change to another employer that is cap subject, you would still have to go through the lottery. So it's not that easy to avoid the lottery, but if you want to work for one of these companies for 6 years, you can definitely do that. And there are certain companies that are similar, like the UN and other like government adjacent organizations that hire people under the G4 visa, which is a whole different category that I'm not going to cover today. Okay, so that was the H-1B, which most people are pretty interested in. Some of these other visa categories I'm going to go over are not as popular if you're not from these countries, so you can kind of zone out if you're not Mexican or Canadian here. For the TN visa, so this was under the former NAFTA agreement, now called the US-Mexico-Canada agreement. And it's a little bit similar to the H-1B in the fact that it's for professional positions, so bachelor degree required positions. But you don't have to go through that LCA prevailing wage process. This is only for Canadian and Mexican citizens. Doesn't matter what country you were born in, as long as you have a passport from one of those countries, and you could be a dual citizen as well, as long as you have the passport of Canada or Mexico. And you have to be working for, or your profession has to be on this qualifying list. So in the statute, they have a list of what they call NAFTA, or I guess now USMCA professions. So a lot of them are like accountant, lawyer, graphic designer, economist. So there's a whole list. There's a lot of scientific positions on there too. But there's a lot of positions that are not listed on there. And sometimes it can be hard to kind of fit your job into one of those categories. And sometimes the government doesn't like when you try to fit a job that doesn't fit into that category. So it can be difficult sometimes to get that if your job is not aligned with one of those professions on the qualifying list. The one that comes to mind is economist. It's very regulated, and especially for Canadian economists, the CBP, like Border Patrol people, where you would apply either at the airport in Canada or at the border, a lot of them really do not like the economist position. So it has to be a really well put together application explaining why you qualify, why the position is actually an economist role, not a financial analyst or any sort of just like finance job. Same with computer systems analyst, sometimes graphic designer. That's kind of one of the only artistic positions on there. I believe industrial designer is on there as well. But you kind of have to go through the list to see if your occupation fits into the TN. If it doesn't, you might not qualify for the TN. And again, you have to have the required education, so usually a bachelor's degree in that field. I have had several applications for clients approved where the person does not have a related degree. I actually just had a TN approved for computer systems analyst for someone with an MBA, but she had kind of enough work experience and course work experience on her transcript to work, and at least the CBP in Houston thought so. But again, it has to be kind of a well thought out and put together petition. You can't just wing that. And you have to have an employer willing to hire you for this type of petition. You can't be self-employed. And then for the application process, it varies depending on whether you're Canadian or Mexican, because Canadians do not need visas. They're visa exempt, so they don't get the actual visa in their passport. And you can apply at the port of entry, so literally crossing the border in a car, or at the airport in Canada, the pre-flight inspection. Don't go to Toronto. I always tell people not to go to Toronto. They have the meanest officers and probably deny the most cases I've ever seen. So if you can avoid it, avoid Toronto, Pearson Airport. Or you can petition with USCIS, which costs more, but if you're in the US and you can't or won't travel, that's an option. But Mexican citizens, if you're outside the US, you can apply at a US consulate and then get the TN visa stamp, or you could apply in the US as well and do that change of status. And you need a support letter from the company outlining the job and the qualifications of the applicant, you, and then you need your proof of education, so your degree and transcript, and then your proof of citizenship, your passport from that country. And that's really it. It's not that complicated of an application, but just depending on the job and whether it kind of fits into that neat little category. I'll kind of skim through the H-1B1 and the E3 because they're basically identical to the H-1B, but without the lottery component. H-1B1 for Singaporean and Chilean citizens, and the E3 is for Australian citizens. So same process where you have to do the prevailing wage, post the LCA notice at the workplace, file the I-129 petition if you're in the US, or if you're outside the US, you can do this at a US consulate abroad. It doesn't necessarily have to be in your home country, although that's recommended. And right now, due to delays and backlogs at consulates, if you're in the US, I would recommend doing a change of status application rather than traveling to a consulate, because there's always the risk that you can have an appointment scheduled, it gets canceled, and then you don't have a visa and you're stuck outside the US, and not every employer is going to wait for people to get their visa. So if you do it in the US, it's a little pricier with the government filing fees, but in it's probably cheaper than a flight to Australia, honestly. So it could end up being better in the long run. And then just kind of special issues with those categories. We haven't talked about dual intent, but dual intent means that you can intend to be a non-immigrant and you can also intend to be a permanent resident. So you can say, if you're an H-1B status, which has dual intent, you can intend to be here temporarily for 6 years, but you can also change your mind and apply for a green card, and that's okay. H-1B1 and E3 do not have dual intent, meaning you're not supposed to apply for a green card when you're in those categories. It can be done, but the timing has to be right. So make sure you speak with an attorney about that. And then the E3 category allows spouses to apply for a work authorization card. So if you apply for an E3 status, your spouse, legal married spouse, not like civil union or anything, your spouse can apply for dependent status as E3D, and they can apply for a work permit and work. Dependents of H-1B and H-1B1 cannot work for the most part. J-1 exchange visas. If you're an F1 staff, you're probably not applying for this after graduation, but there are several different categories. Some of you might be on the J-1 research scholar visa right now. And this is a category intended for an exchange of cultural ideas, and is run through the Department of State and uses a sponsor agency. So it's a little different than like applying through USCIS. But kind of the main issue with the J-1 is the 2-year home residency requirement. So for some people, depending on the country, the skills of the occupation you'll be training in, or the funding of how you get the visa might require you to return to your home country for 2 years at the end of your visa status. You can get a waiver for this in particular circumstances, and there's kind of different grounds to waive it. Sometimes it's easier than others. Sometimes a waiver is never issued, like Fulbright scholars. It's kind of notorious that if you're a Fulbright scholar, you have to do if you're subject to the 2-year requirement, you have to do it. And then medical graduates have kind of special exceptions as well. Okay, the O1 category. So I've gotten a lot of questions about this from new school students in the past. So the O1 is the extraordinary ability visa, and there's 2 subcategories. The O1A is for science, education, business, or athletics, and then the O1B is for arts or motion picture, television industry. And I think a lot of people misinterpret the O1 as just a visa for artists, which is true, but you have to be at the very top percentage of your field to qualify for this visa. So you have to be extraordinary. So kind of what is required to qualify for the O1 extraordinary ability visa, and what you have to show the government to prove that you are extraordinary, because it's very subjective, this category. It's not just, are you an engineer? Do you have an engineering degree? Okay, you're approved. It is really subjective. But what they look for, you have to meet certain criteria. So 1, either you have a Grammy, an Oscar, an Emmy, one of those kind of high achievement awards. If you have one of those, you kind of automatically get in. If you don't have your Oscar, then you're going to have to qualify under certain other criteria, which can be letters of support from other experts in the field that know you and can attest to your extraordinary ability or your kind of critical capacity at certain organizations with distinguished reputations. Their publications value in major publications or trade publications. You have a high salary for the field. There's media and citations and press about you, so lots of articles and things like that. If you judge others' work, so if you're on a panel judging others as kind of you're the expert and you get to judge others in the field, that's one criteria. You've received awards in the field or other critical acclaim. If you're a member of selective professional memberships, so not just some organization that you can sign up for, but you either like have to be invited or you have to be kind of one of the best in the business to be in that group. And kind of one of the main criteria that most people use is employment in a critical or essential capacity for organizations with a distinguished reputation, and then you also will be in the future. So usually the company hiring you and sponsoring you for the O1, if you do it with a company, they'll show that they're a distinguished company. So if they're big and famous and have lots of critical acclaim and you're working for them and you've done lots of, you've been in a critical capacity for that organization, then you can show like, okay, he or she has done this. Like if it's an artistic thing, you've had exhibits with this gallery that has a distinguished reputation, things like that. But you have to meet at least 3 of these categories. In my clients' applications, I try to use as many as possible because sometimes the government won't accept all of them. But you just kind of try to argue as many of them that you possibly can. And then as long as you have 3 of them, then you could qualify. And so the O1 has a period of stay for up to 3 years with extensions in 1-year increments. And there's no maximum limit. You could keep extending as long as you're still extraordinary, still qualify, you can keep applying. And family members can get O3 dependent visas that do not permit work authorization, but they can go to school. So that is one downside, that your spouse can't work if they need the dependent visa. And you also may apply through either an employer or an agent, which is different than other visa categories where you have to have the employer. If you're in an O1 occupation that is very kind of gig heavy, like photographer, actor, dancer, you're probably not working for the same employer for 3 years straight. You might be working on this job for 2 months and then this other job for 2 months or even less. So you can have a lot of contracts lined up with different employers, showing that you have continued work for that time period. And then just the petition is filed through a sponsor agent. So it could be like your talent agency if you have that, or it could be, sometimes it's like a CPA accountant that is acting as your agent in that capacity. And then just one last thing, the petitioner, the company, whoever is filing for you, must obtain a written advisory opinion from a peer group in the area of expertise. So this comes into play in most occupations where there are unions. So a lot of artistic fields have unions. So I just have as an example of photographers, you have to get an advisory opinion from IATSE. And each kind of occupation has kind of different peer groups. Some of them don't have one. You don't have to file one, but it really just depends on the job. And some groups are easier to get an opinion than others. Most of them on those union websites, they have a section on how to do that. And they usually just need a copy of the petition. They look at it and they say, okay, and they issue like a template letter that you include in the application. Okay, so that was, I'm kind of running low on time because I want to get to Q&A. So I'll just kind of skim over the green card section very quickly because most of you will probably be going for non-immigrant visas rather than straight for the green card. But the green card is kind of the next step after you get your non-immigrant visa if your company will apply for you. So this is just an overview of the steps of the green card process if you're going through an employer rather than a family member. Most people get their green card through the PERM labor certification process, which is testing of the labor market, where the employer will have to test the local labor market they'll put out ads for that position that you're in or applying for, saying like, okay, are there any minimally qualified US workers in this geographic area who are qualified for this job, who want it, who apply for it. So they post these ads, they're in newspapers, they're on websites, and they basically just collect resumes and see if a minimally qualified US worker applies. If they do, then you can continue the green card process. If they don't, then they'll continue the green card process, but it's just one hurdle that you have to get over. And that process, unfortunately, takes about 16 months right now, because there's additional components within there. There's that prevailing wage again, but you have to request it from the DOL instead of choosing your own wage level. You have to post those ads for a certain period of time in a very strict way that the government requires. So like I said, newspaper ads, like I don't think like you guys are probably 20, 22 years old. I don't think you've ever applied for a job out of a newspaper, but the regulations are so antiquated that they require Sunday newspaper ads. So if you ever pick up a New York Times on Sunday, look at the classified section and you'll see a bunch of perm ads. And I think that's who's kind of keeping the New York Times in business with their classified ads there. And then after you get the perm labor certification, the company would file an I-140 petition for you. And then number 3 there, the adjustment of status. If your country does not have a green card backlog, which I'll get to, then you can simultaneously apply for your I-140 and your adjustment of status. Those are steps 2 and 3 of the green card. If your country does have a backlog, you cannot get to step 3, adjustment of status or consular processing, until your category for your country becomes current, and I'll explain what that means. Let's see, I'll kind of skip this one. Okay, so there's quotas on green cards. There's 140,000 employment-based green cards issued per year and 226,000 family-based. So no country, it's not an exact number per country that's allowed, because they call it per country quotas, but no country's permitted more than 7% of the amount of visas. So it's really kind of a supply and demand issue that they kind of see as it goes along. So this creates supply and demand issues for countries that have a very high demand, like mostly China and India right now. In the past, Mexico, Philippines have also been in backlogs. And then those with that higher demand kind of get stuck in this backlog where they have to wait for their priority date to become current. And I'll explain what that means. So this is the September 2021 Visa Bulletin. The Visa Bulletin is a chart that's issued each month by the Department of State. It's posted on their website, and this shows who can apply for green cards in which category. Now, it's kind of hard to decipher if you don't know the lingo, but so this is the employment-based chart. They also have a family-based chart. But if you are in the EB2 category, so this is either advanced degree positions, or if you have a bachelor's plus 5 years experience, so that's EB2 green card. And if you were born in India, right now for September 2021, they're processing green card applications that were filed in September 1st, 2011. So that's a whole 10 years from yesterday. So that's quite a backlog. This is actually better than it used to be, but it's still pretty terrible to wait 10 years, 10 plus years for your green card. The boxes there that you see that have a C, that means current. So EB2, all chargeability, that means any country except the ones listed there at the top. So France, Brazil, South Africa, any other country, they're current, and they could file their I-140 and adjustment of status application just at the same time and don't have to wait. People from China and India have really long backlogs. This is mostly for EB2 and EB3 in the employment-based context. It says China mainland born there, but as of last year, Hong Kong is included in the China, mainland China chargeability area. So Hong Kong used to kind of get to skip this backlog, not anymore, which is unfortunate. But nothing can really be done about these backlogs. It's a supply and demand issue, and they don't move at real time. So when we get the October visa bulletin, that September 1st, 2011 date, it might move up 6 months. It might move 2 days. It's really kind of hard to determine exactly how it will move depending on how many people apply for visas, how many visas are issued from each country. So that's just kind of how it works. If you're from one of those countries with extremely long backlogs and you're in, say, H-1B status, you can extend your H-1B beyond that 6-year period while that you're waiting for your category to become current. If you already have that parts 1 and 2 completed of your green card, the perm and the I-140. So if you have an approved I-140, but you just can't file the last stage because your date is so backlogged, then you can continue to extend your H-1B until that date becomes current. For Indian nationals, that means being in H-1B status for a long time, quite frankly. I've seen people for 10, 15 years, and it really just depends on how the dates move along. If they all got cleared one day, then everybody could apply for their green cards. That happened in 2007, I think. And they just cleared all these dates and everything was current. Okay, so those are the main categories that require the perm labor certification. The EB1 category for extraordinary ability, outstanding researcher, multinational managers, do not require that labor test, labor market test with the perm and the ads and everything. So you get to skip that. National interest waiver, so that's an EB2 category, but you also get to skip the perm process if your occupation is in the national interest of the country. It's a little difficult, and there's very particular criteria that you have to meet to show that your job meets that. Usually it's done with occupations that are very kind of academic, and you have papers and citations and things like that, kind of similar to the outstanding researcher. Okay, and then just last slide before questions. COVID-19 restrictions. There are still travel bans into the US from UK, Ireland, Schengen region, in Europe, Brazil, Iran, China, India, and South Africa. If you've been in any of these countries or regions within the last 14 days, you cannot enter the US unless you have a national interest exception. F1 students are eligible for that national interest exception automatically, which is great. But if you switch over to one of these work visas, like an H-1B, you're no longer eligible for that. So say you went to France to go get your H-1B visa, then you might have to get your visa stamp at the consulate if you can get an appointment in Paris, but then you might be stuck in France unless you could get one of these exceptions, which are pretty hard to get these days. Many of the consulates are still processing only emergency applications, so you have to check your location, especially before you travel. Don't get stuck outside the US. And then COVID test, everyone, including US citizens, has to get have a negative COVID test within 3 days of travel to the US. And you can get that in your country or at your hotel. One thing I'll just note about these travel bans, what I recommend for most people, especially coming from Europe, to avoid this, if you cannot get a national interest exception waiver, is travel to Mexico for 14 days, if that's possible. That's kind of a way around it. So once you've been in Mexico for 14 days, then you can, you haven't been in one of these regions in the last 14 days, do your negative COVID test, and then enter the US. It's obviously a very privileged thing if you're able to travel to Mexico for 14 days and stay in a hotel, but that is one of the kind of ways around it. Or if your employer, if you have an employer that is willing to pay for that, then that's even better. Then you get to hang out on the beach for 14 days. Okay, so that's everything. I kind of skimmed through some things that I thought were maybe not as interesting to your group, but I'll take a look at kind of the chat here.
There were a few questions that I answered.
Okay, great.
But there were a couple of questions that were very interesting regarding, remember when you mentioned that you can do change of status from within, from OPT to H-1B?
Mm-hmm.
So if a student has a valid I-20 and a valid EAD card, but their visa is expired and they do a change of status from within the United States, will they be able to leave?
So yes, so that's a good question. You can always leave. The problem's coming back. To come back, if you do that change of status, so you would change status on October 1st. Say you want to go to your home country for Christmas or the holidays in December. If you leave the country after you've already changed over to H-1B status, you need that H-1B visa stamp in your passport to return. You can't re-enter on your F-1 visa when you're in H-1B status. So that's another kind of tricky point right now about the appointments. So I recommend, if you have plans to travel anywhere, probably within 6 months of October 1st, look for appointments early and see when the earliest appointment at the US consulate in your country is, or wherever you're going is, and then you can kind of coordinate travel around that, because you cannot re-enter the US until you get that H-1B visa stamp. Again, this used to be so much easier in the past when there weren't all these COVID restrictions. People used to just go and get their visa at Christmas time when they went to visit their family over break. But right now, a lot of countries don't even have appointments left this year.
Yeah, I think like a lot of students had a hard time coming in, so
yeah,
I would stay put where you are if possible.
Yeah, that's kind of the safest option right now.
A few H-1B questions that regarding lottery, just your guess in terms of, does it increase your chances? Do they increase depending on your wage level? And do you think, what were the percentages in the past, like before the last year? You said it was 30%, right? Is that lower than before? And do you see anything happening with that number due to changes in administration or?
Yeah. Okay, so I'll tackle the first question about wages. I actually took out a slide that just for time's sake about, so the Trump administration issued a new rule kind of very much at the end of his administration. I think it was in January 2020, of redoing the H-1B lottery process in a way that instead of doing this randomized lottery where everyone submits their name and they just kind of pick randomly, they want to do, or they wanted the Trump administration to do a wage preference selection process where people with higher wages get preference and get selected first. Obviously, this is not good for international students who are applying for entry-level positions. They're just graduating from school and might have the lower of the wages for H-1B positions. That there was litigation, lawsuits that was put on hold. Although this past July, when there was a motion on the case, and the Biden administration kind of defended the rule. It doesn't mean it's going into effect, but the Biden administration still kind of agreed with this policy of the wage preference. So I don't know exactly what will happen in the future. It's definitely possible that that could go into effect, maybe not next year, maybe the year after, depending on this litigation. But it's something that doesn't really bode well for international students and doesn't reflect, it's kind of a contradiction of Biden's support of international students. He's been very kind of vocally supportive of international students, saying they contribute a lot to the US and many want to become Americans and contribute to society, but this kind of contradicts that message when it will certainly not help international students. So that's something to kind of keep an eye on in the immigration sphere. The second part was the odds and statistics. So this past year was 30%. I don't know the numbers off the top of my head from previous years, but it was better. Still not great. It was in the 30s, maybe 40%. One thing, I don't think it's necessarily a change of administration thing, but it's a change of process going from the old way where you used to have to file the H-1B petition, pay the fees, you had to pay, the company had to pay several $1,000s in government fees, hire a lawyer, complete these applications and file it, and then it might not get selected. Now it's just this $10 online fee and this registration form. You don't have to do the whole application until someone's selected. That has boosted the number of applicants into the lottery because they're making it easier for employers. So by making it easier and cheaper for them, it causes more of a demand. So that causes the odds in turn to go down because more people enter the lottery. So this year, I know was definitely the lowest. It was the most amount of people ever entering the lottery, which in turn, the quota remains the same. So the lowest odds of being selected this past year, and I don't really see that changing. It'll probably be similar, and it sometimes changes based on the economy and who's hiring. During the economic downturn in 2008, 2009, they still had the lottery, but the lottery didn't fill up until Thanksgiving in like 2010, 2011. Like it wasn't like it was now where like they meet the quota in the first few days of the applications. They didn't even have 60 or 85,000 people apply for H-1Bs by Thanksgiving time, starting April 1st, just because people weren't hiring. So the economy definitely affects it. But I think generally, based on how many people applied this year, it will probably keep filling up quickly in years to come, at least recent years to come.
Thank you so much. And there were a few questions regarding outstanding researcher visa. Students are asking to give kind of what qualifies, I know you talked about O1 visa and being extraordinary in terms of the arts and creative jobs, but in terms of what goes for being an outstanding researcher, what kind of evidence are they looking for?
Yeah, so it is very similar to the O1 or extraordinary ability green card, but primarily just for researchers. It's for scientific positions. A lot of what they're looking for in the criteria is academic papers. If you have published papers, conferences, articles, citations, they use a lot of Google Scholar. So if you look up your Google Scholar and you have 30 papers published, but also like 800 citations, and I'm just making up those numbers, but like if you have a lot of citations and published papers in your industry, if you've done anything of like original contribution in your industry, like if you kind of discovered something in your lab, then you might qualify as an outstanding researcher. I've done some outstanding researcher applications for people in pharmaceutical work, which is kind of a popular category, basically like any scientific category, but pharmaceutical work and like engineering are pretty kind of the main categories for that. I've never actually done one that's not for a scientific field. If you're a researcher in maybe international studies or something like that, it's a little different. And it might be a little more difficult to get because that's not the main kind of categories, but you can also maybe qualify for extraordinary ability. It depends on what your qualifications are. And you can kind of look at both categories to see which one is the best fit. And same with visas as well, because sometimes you might fit into the H-1B category and you don't get selected, but you're Canadian or Mexican, so you can fall back on the TN, or you're Australian, you could get an E3. Not everybody has those options of like being qualified for multiple categories, but if you do, it's a great benefit where you can just kind of look at your job, your qualifications, and then kind of expand and see what you might qualify for. And sometimes if you don't qualify for a work visa, maybe you have a family visa option, or maybe you have a humanitarian visa option. You might be eligible for asylum, depending on where you're from and your home country conditions and things like that. Oftentimes there's more options than people realize. They think, oh, I need to get the H-1B, but they might actually fit into another category better that will work out better for them.
I just want to say that if you're considering your options for after OPT or STEM OPT, you have Lauren's information here, book a consultation and go over all of your options so you're best equipped to make the right decisions. I know that there are a lot of questions here regarding H-1B too, but I just wanted to pick out a couple of questions that I think kind of information that is new. One is multinational manager. What kind of seniority does that visa require?
Okay, so the multinational manager category is for someone, so it's very similar to the L1 visa that I didn't cover, because you have to be working for a foreign company, multinational company. So they have an entity abroad, say in London, and then they have an office in New York, and they want to transfer you from London office to New York, and you've been a manager at their London office, and you'll be a manager at the US New York office. That's an L1A visa. The extraordinary or the multinational manager green card is basically the same thing. It's an L1A in green card form. But the reason I didn't discuss that is because, I mean, all of you are going to school in the US, so it's unlikely that you would qualify for this multinational manager, because you have to have worked at least 1 year for the qualifying company outside the US within the last 3 years. So it's possible if after graduation you go back to your home country, you work for a multinational company, and they want to transfer you to the US, and they can file your green card if you've been a manager at that entity abroad and you're going to be a manager in the US, but that's kind of a less likely category, I think, for students in the US, but certainly potentially could be an option. And if you think that's an option for you, you can definitely reach out to me for a consultation and to discuss that, to see if that is an option. And I'm actually going to put my link to my consultation scheduling. I just dropped it in the chat. So if you do want to schedule a consultation with me to talk privately about your immigration issue, or if your employer wants to schedule one, you can schedule through that link, or you can email me or call me as well.
Thank you. There are a couple of questions regarding, so I think if I'm interpreting the question correctly, it has to do with work options after OPT. What happens if a student establishes an LLC, right? And they finish their OPT, can they sponsor themselves, or what other options do they have?
Yeah, so I think, so you can be self-employed during your OPT period. You cannot during STEM OPT, which gets tricky if you qualify for STEM OPT. So if you say you start your own LLC and your own business during your 12 months of OPT time, when it comes time to extend that STEM OPT, you can't really be self-employed because you have to have a manager sign off on that training plan, unless you set up the company where somehow one of the other founder, you have partners and they're signing the form, but it has to be done properly. If you're completely done with your OPT time, the best way to start your own company in the US is the E1 or E2 visa. So this is the E1 is the trader visa, and the E2 is the investor visa. So investor, if you're going to start your own business or buy an existing business, you have to be from a certain treaty country. So certain countries have treaties with the US for this visa, not every country. The Department of State has a list of countries that are eligible. And if your country, your citizenship country is on that list, you may be eligible. You have to have the rules say a substantial investment. There's no dollar amount that's regulated, but I've never seen one really for under $50,000 or $75,000 investment. Usually it's a pretty significant investment that's required. It has to be an at-risk investment, so it can't just be like a real estate investment where you just buy a building and let it appreciate and sell it. It has to be an at-risk investment. You have to be involved in the business. It's, I don't want to say difficult, but it is a lot more complicated. There's a lot of financial documents that go into this, and the company has to be at least 50% owned by individuals from that treaty country. So if you're from Australia and you want to start a business with your friends, and you have two other friends that are going to be now business partners, if those two other friends are US citizens or citizens of other countries that are not Australia, then you cannot get the E3 or the E2 visa for that, because assuming your ownership of the company is equal in that situation, then 1/3 of the company would be Australian owned and not 50%. So you would have to work out the ownership percentages. And then if you sell the company, things like that, that changes the ownership percentage. So there's a lot of moving pieces. It's definitely possible. I've worked with some new school students talking about trading the E1 trader visa and starting companies where they're importing goods from other countries. So that's definitely a possibility as well. But those are kind of the main entrepreneur visa options. Unfortunately, there's not a lot of entrepreneur business owner visas, visa categories. There is the international entrepreneur parole that was just kind of re-implemented this year, that was kind of put into place by the Obama administration and like kind of his very last days, and then was Trump put the kibosh on it immediately. But now it's back this year, but that's more of if you have venture capitalists investing into your business, then you can qualify for, it's not a visa, it's not a green card, it's parole for a few years. But that's also another option that can be investigated as well.
Thank you. Another great question. I know we have 3 minutes here left. I know that some of our students have been successful in obtaining F1 visas in countries other than their own due to COVID craziness. Do you know, in case of obtaining like H-1B, for instance, can they apply for it in countries other than their own?
It really depends on the particular consulate where they want to go. Some consulates permit, so they call it a third country national if you're applying in a country that you are not a citizen of, or not, yeah, I guess not a citizen. You have to look at the consulate website. Sometimes they specifically say, like Mexico right now is not taking third country nationals unless you have residency in Mexico. So say you're a UK citizen, but you have residency in Mexico, or your parents live in Mexico or something, you might be able to qualify to get an appointment there. But if you have no relation to Mexico and you're just kind of there as a visitor, you likely cannot get an appointment right now. And this is basically because of COVID, because everybody wants to go to Mexico and Canada because they're close.
Yeah.
But in the past, Mexico was processing these applications. You really kind of have to check in with each consulate. I was actually just looking for a client today who's Australian and is having trouble getting an appointment in Australia because they can't travel like to each province, like they have COVID restrictions. It might even be easier for him to go to Hong Kong because it says on the website, it says anyone who's legally in Hong Kong can apply for an appointment there, but Hong Kong also has COVID restrictions for travelers from outside the country. So it's kind of a web of, will the consulate allow it? If yes, can you get into that country? If yes, then great, but not all of those stars align all the time.
I think also, you know, so with COVID right now, I don't know if, is Canada border even open to Americans yet?
Yeah, the Canadian border opened, I think it was the beginning of August. That opened. There's still some kind of like testing obligation, obviously coming back, there's the testing obligations. I'm not sure if they have the quarantine. Oh no, I think they don't have the quarantine restriction if you're vaccinated in Canada. But always for Canada and any other country, always just kind of check that government's COVID restrictions, because you don't want to show up somewhere where you might be eligible to go in, but you have to go stay in a hotel for 14 days or something like that.
Thank you so much. This brings us to 6:30. That went so fast. Thank you so much, Lauren, for such a detailed presentation. And we will post the recording on social media, and I'll include it in the newsletter. I encourage you, please screenshot the slides so you have Lauren's information. I also repost it on our social media too. You can always reach out to her, and this recording can be shared with you too. Thank you so much for doing this for us today.
Great. Thank you so much for everyone for joining and for your great questions. And if you have any other questions that you want to ask me, there's my email up there. All my social media is Lauren Jo Law. You can DM me. I'm pretty active on Instagram. You can send me a DM on there, shoot me an email, call.
I love your Instagram. It's so fun.
You can call, text that number if you have questions. Let me know you're from the new school. And I'd be happy to talk to any of you.
Thank you, everybody. Have a wonderful day, and great to see you again. Thank you so much.
Thank you. Bye-bye. Have a great night, everyone.
Bye.